Hello, this presentation is to help with preparation for my courses on summary judgment, to supplement the pre-reading and to allow better use of limited time in face-to-face seminars. There's no discussion of procedure or evidence here. I just concentrate on the test which the English court applies when deciding whether to grant summary judgment. CPR 24.2 sets out the grounds for summary judgment, and it reads as follows. The court may give summary judgment against a claimant or a defendant on the whole of a claim or on a particular issue if it considers that 1. The claimant has no real prospect of succeeding on the claim or issue, or 2. That the defendant has no real prospect of successfully defending the claim or issue, and B. There is no other compelling reason why the case or issue should be disposed of at a trial. The general scheme of this provision is that there are two separate considerations relevant to the question whether summary judgment should be granted. The first, in A, deals with when summary judgment will be granted, and the second, in B, when it will be denied. This drafting has been widely criticised on a number of grounds. First, the words "and there is no other" in B are not grammatically appropriate. The respondent's lack of real prospect of success isn't a reason why the claim should be disposed of at trial. It's the opposite. In Miller and Garton Shires, Mr. Justice Lindsay said of those words, "The word other in B is inept, as read literally, it would suggest that the fact that a claimant has no real prospect of success, or a defendant none of successfully defending, would be a compelling reason why the case or issue should be disposed of at a trial. Plainly, that was not intended, and the word other is to be given weight by reading the rule as if it said that, notwithstanding the absence of real prospect of success, nevertheless, there is some reason why the case should go to trial." The second drafting criticism is that the word case in B is simply the wrong word. The word claim is used elsewhere in the provision, and there seems to be no possible reason for using a different word here. Under the rules of the Supreme Court, which applied until 1999, completely different provisions applied to summary judgment on the entire claim and on individual issues. But CPR 24 covers both. However, the distinction is still extremely important because the effect of the applicant failing in the application is quite different in the two cases. Where the claimant or the defendant fails to obtain summary judgment in respect of the whole claim, the action will proceed to trial and the applicant will have another bite at the cherry. When the applicant has failed to obtain summary judgment in respect of an individual issue, on the other hand, then a final determination is made and an issue estoppel arises, so it's no longer open for determination at trial. The only recourse of an unsuccessful applicant in these circumstances is an appeal against the summary judgment order. Before 1999, the test for summary judgment was whether the respondent had an arguable case. This compared with case law on the test applicable to a defendant seeking to set aside a regular judgment signed in default, which was the higher threshold of showing a defence which had a real prospect of success. The civil procedure rules brought the two tests, respectively in Part 24, summary judgment, and Part 13.3, setting aside default judgments, into line. The single test now is real prospect of success. It follows that it should be easier to obtain summary judgment under Part 24 than it was under Order 14 of the Rules of the Supreme Court. After 1999, the first time the court considered the meaning of real prospect of success was in the context of setting aside a regular default judgment, and that was in the international finance case. In that case, Mr. Justice Moore-Bick said this: "To say that a case has no realistic prospect of success is generally much the same as saying it is hopeless, whereas to say that the case has a realistic prospect of success suggests something better than that it is merely arguable. Something more than a merely arguable case is needed to tip the balance of justice. The expression realistic prospect of success in this context means a case which carries a real conviction." This analysis was adopted and expanded by the Court of Appeal in the EDF Mann case, where Lord Justice Potter said this: "In my view, the only significant difference between the provisions of CPR 24.2 and 13.3 is that under the former, summary judgment, the overall burden of proof rests on the claimant to establish that there are grounds for his belief that the respondent has no real prospect of success, whereas under the latter, setting aside a default judgment, the burden rests on the defendant to satisfy the court that there is good reason why a judgment regularly obtained should be set aside. That being so, although generally the burden of proof is in practice of only marginal importance in relation to the assessment of evidence, it seems almost inevitable that in particular cases a defendant applying under CPR 13 may encounter a court less receptive to applying the test in his favour than if he were a defendant advancing a timely ground of resistance to summary judgment under Part 24. Under the old rules, the defendant could avoid summary judgment by showing some other reason for trial. It appears that no other compelling reason is broadly similar. The compelling was added in the year 2000 to head off very flimsy reasons for going to trial. Examples of no other compelling reason for a trial, based on the cases decided under the old provision, would include: first, the claimant's case appears to be devious and crafty and not plain and straightforward, that the defendant is an executor or an administrator who can raise facts by reference to the existence or absence of letters or accounts or such like of the deceased which make it reasonable to require a full investigation, or that the claimant's case tends to show that he acted harshly and unconscionably and that it was thought desirable that if he were to get judgment at all it should be in the light of full publicity, or that the claimant is incapable of giving or has not given a retainer to bring the action to start with, or that the defendant reasonably and properly requires to cross-examine the claimant. Generally, the courts are anxious to avoid applications for summary judgment turning into mini-trials, and if the application would do so, this will be a ground for dismissing the application. So, even in a case where the court might eventually be satisfied that there is no reasonable prospect of the respondent succeeding, the application will still be dismissed if reaching that point would require too elaborate a hearing. The leading case is Swain and Hillman, in which Lord Woolf said this: "Useful though the power is under Part 24, it's important that it is kept to its proper role. It is not meant to dispense with the need for a trial where there are issues which should be investigated at the trial. As Mr. Bidder put it in his submissions, the proper disposal of an issue under Part 24 does not involve the judge conducting a mini-trial. That is not the object of the provision, and it is enabled to enable cases where there is no real prospect of success either way to be disposed of summarily." In Three Rivers and the Bank of England No. 3, a case described by the Court of Appeal in Miller and Garton Shires as perhaps now to be seen as the high water mark of allowing cases to go to trial, Lord Hope of Craighead said this: "The simpler the case, the easier it is likely to be to resort to what is properly called summary judgment. But more complex cases are unlikely to be capable of being resolved in that way without conducting a mini-trial on the documents, without discovery, and without oral evidence. As Lord Woolf said in Swain and Hillman, that is not the object of the rule. It is designed to deal with cases that are not fit for trial at all." That's all on this presentation. All of these topics are covered more fully in the notes which accompany the course, and those notes also deal with procedure, evidence, and tactical matters.